Trademark registration in key Pacific Islands. The Pacific Island nations are characterized by remote locations, small populations, and exceedingly limited resources, where obtaining trademark protection can be less than straightforward, and the process corresponding to trademark registration can at times prove to be a little arduous and challenging. So, let us now make ourselves familiar with laws of trademark protection and registration in key Pacific Island nations, including Fiji, Kiribati, Papua New Guinea, Samoa, Solomon Islands, Tonga, Tuvalu, and Vanuatu, one by one. Trademark registration, Fiji. Fiji, also officially known as the Republic of Fiji, is an island country in Melanesia in the South Pacific. With an archipelago of even more than 330 islands, the country has a total land area of somewhere around 18,300 square kilometers. In Fiji, the Trademarks Act of 1933 governs and deals with the mechanism of trademark registration, which is, in turn, based on the UK Trademarks Act of 1905. Trademark registration and protection in Fiji may be obtained by filing a national trademark application. Trademark protection for independent trademark registration is valid for 14 years from the date of application in Fiji, which is further renewable for periods of 14 years. Trademark registration, Kiribati. Kiribati, also officially known as the Republic of Kiribati, is a country in the Central Pacific Ocean with a total land area of 800 square kilometers. The registration of United Kingdom Trademarks Ordinance Cap 88, which is in force since the 22nd of August 1939, forms the legal basis of trademark registration in Kiribati. Only the trademark owner of a UK-based trademark registration for the same mark corresponding to the same goods can apply in Kiribati as well, for which authorization of agent and the certified copy of the UK trademark registration are required. Trademark protection in Kiribati ends corresponding to the registration term of the UK-based trademark. Trademark registration, Papua New Guinea. Papua New Guinea, also officially known as the independent state of Papua New Guinea, is a country in Oceania in the southwestern Pacific. As the world's third-largest island country, Papua New Guinea has a total area of 462,840 square kilometers. The law of 1978, which is in force since 1980, governs and deals with the mechanism of trademark registration in Papua New Guinea. Trademark protection can be obtained by registration and can also be acquired with sufficient public recognition. Collective marks, 3D marks, quality marks, certification marks can be registered in Papua New Guinea. Trademark protection is valid for 10 years from the date of registration in Papua New Guinea, which is further renewable for periods of 10 years. Trademark registration, Samoa. Samoa, which is also officially known as the independent state of Samoa, and, until 4 July 1997, known as Western Samoa, is a country consisting of two prime islands, namely Upolu and Savaii. The Intellectual Property Act 2011, which is in force since 1 October 2012, and the Intellectual Property Amendment Act 2018 together form the legal basis of trademark registration in Samoa. The national trademark application can be filed with the Ministry of Commerce, Industry and Labour directly. Trademark protection is valid for 10 years from the date of application in Samoa, which is further renewable for periods of 10 years. Trademark registration, Solomon Islands. Consisting of 6 major islands, Solomon Islands is a sovereign state in Oceania with a total land area of 28,400 square kilometers. The registration of United Kingdom Trademarks Ordinance, Chapter 180, which is in force since 20 June 1939, governs and deals with the mechanism of trademark registration in the Solomon Islands. Trademark registrations in the Solomon Islands must be corresponding to a UK-based trademark registration, which is then, in turn, re-registered with the Registrar General of the Solomon Islands directly. Trademark protection in the Solomon Islands ends corresponding to the registration term of the UK-based trademark. Trademark registration, Tonga. Tonga, also officially known as the Kingdom of Tonga, is an archipelago consisting of 169 islands and a Polynesian sovereign state with a total surface area of 750 square kilometers. The Industrial Property Act of 1994, effective from 1 February 2000, forms the legal basis of trademark registration in Tonga. It has its independent trademark registration system. Trademark protection is valid for 10 years from the date of application in Tonga, which is further renewable for periods of 10 years. Trademark registration, Tuvalu. Tuvalu, also formerly known as the Ellis Islands, is a country in Polynesia with a total land area of its islands of 26 square kilometers. The registration of United Kingdom Trademarks Ordinance (Cap. 63), which is in force since the 22nd of August 1939, governs and deals with the mechanism of trademark registration in Tuvalu. Only the trademark owner of a UK-based trademark registration can apply for the same mark corresponding to the same goods or services in Tuvalu, for which an authorization of agent and a certified copy of the UK-based trademark registration are required. Trademark protection in Tuvalu ends corresponding to the registration term of the UK-based trademark. Trademark registration, Vanuatu. Vanuatu, officially known as the Republic of Vanuatu, is a Pacific island country in the South Pacific Ocean. The Vanuatu Trademarks Act 2003, which came into force on 8 February 2011, forms the legal basis of trademark registration. A trademark application in Vanuatu can't cover a series of marks. Trademark protection is valid for 10 years from the date of application in Vanuatu, which is further renewable for periods of 10 years.